How about now? Can you hear me? I think you can hear me now. Yes. All right, let's get started. I apologize. I'll get to your questions. I have email. People got ahead. I had a list of questions. People, if you got the invite, got to send me questions, so I'll send you questions. Mr. Jones, Nan Jones says, "What's the best way, in your opinion, in experience, to learn court procedures?" Oh goodness, how many videos have I done on this? Just go to court at least a week before your time and watch. If it's a Zoom, go to the public website and watch. Watch for people that, like yourself, are perhaps not represented. How does the judge treat those people? How is the staff? But I like in person, and that takes away the anxiety. I just did a great video on this checklist. Hathaway says, "I've sent letters out with interesting codes. Should I do an identity theft report?" There's many ways to handle identity theft. Send out your dispute letters. If it is identity theft, please get a police report. Judges, courts, other lawyers do not take you seriously without a police report, either county level or local level. And so when you have that, you fill out the FTC ID theft. There's a whole bunch of agencies that hand out ID theft affidavits. Those should be included with your dispute. So you have 3 credit bureaus and the furnisher or anybody who's listing you as getting credit, but you didn't. Send them all the dispute letters with the police report, with your ID theft affidavit, everything that shows it's not you. It's a little bit of work. The more work you do now, the less you'll have to do in the future. I'm being sued by a plumbing company, says Wesley. For services rendered, I am not responsible. The services rendered, I don't own, nor do I live at the property. I would love this case. That's a great case. If you get an attorney, great, depending on how much they're suing you for, but you are in line to get some money damages. Make sure you just send them a copy of your ID and an envelope of the current address you're at, and make your own affidavit saying, I did not ask for these services. They keep it going. You counterclaim for money damages for suing you improperly. Hi, Mr. Parker. I have an ongoing suit, says Frank GM Petro. I have an ongoing suit, Velocity, for upstart loan. Long story short, Velocity's attorneys try to move forward with a motion for summary judgment. I have used ParkerGPT to respond, focusing on the lack of chain of title. Yeah, I've done a lot of videos on that. The judge sided with me, and we are now scheduled for a pretrial and bench trial early in 2026. Thank you for the help. I am nervous about meeting next steps, but also confident they have a chance now. Yeah, ParkerGPT. I had somebody call me up and show me that they went to court with their phone and were engaging in settlement discussions, run out to where they're allowed to use the phone, and advised ParkerGPT what's going on. It said, do this, do this. She went back and forth with ParkerGPT. She got the case settled. If I can find that email, I'll send it over to you. I'll publish it. I sent out 2 cease and desist letters to Portfolio Recovery, and they keep calling, etc. Yeah, can you sue? Asks Cheryl Sanico. You darn right you can. I'd take that case. Just make sure you sent the cease and desist, as I always advise, with a certified letter where they're signing, certified by mail, show by a paper trail. Appreciate your help, Cheryl Sanico. I got a cat asking for attention here. This is from my personal experience in VA, says Will. I've learned that GDC is very credit friendly, so in most cases, defendants need to be prepared to lose the first battle. The battle is better fought in circuit court. That is, when I first started doing this, there was a case came along, Maisie Green versus PRA. And on her own, she took it all the way up. And the case was so damaging, it was for portfolio recovery. They brought in $600,000 attorneys and just stacked the deck against her. And she had won all the way. And the appeals court suddenly took an interest in her case amongst the millions of cases that are filed because it was so damaging for the industry. I think someone pushed some buttons or called in some favors. So suddenly the appeals court, en banc, I think it was, said, we want to take a look at this again, even though the case is done and appealed and she won. And they turned it over on her. So there's a interesting experience in Virginia, but that email person is right. The appeals court is where to go, unfortunately. So make a record. So if you're ever in a court where you're like, this guy's biased against me, he's not listening to me, he's biased on this side, start saying things on the record. Sound like a moron. What do I mean by that? Say, oh, Judge, you just looked at me funny. The judge is going to be, you got to put it on the record. Judge, you kind of smiled on that side, but you kind of give me a bad face every time I just ask a question. Put it on the record. Just sounds weird, but I've had cases where I've won appeals just on the record. Like I had a case, a really good case. The client did the appeal and didn't do a good job. Hi, Steve. Steve Lato, everybody. Best channel to go to. Go check it out. Lato Law. It's a folksy, matter-of-fact review of some really cool stories in the news that he adds a lawyer perspective. It's Steve Lato, Lato Law. I hope I got that right, Steve. You just popped up. But I got to finish this. So make sure you get everything in on the record. For a Discover Bank lawsuit, I'm still confused, says Liz Varela. I'm still confused if I should do a motion to miss or an answer. I've answered that several times. See all of my last couple of videos. The one that went up today talks specifically about that. So did the one I just did this week, I think. It just has the one word, merger. Check that video out. Remember to go to, if you can, I put everything on YouTube, but I don't put the important stuff. And the access to ParkerGPT is phenomenal. It'll change your world. You've got this lawsuit against you. Maybe you're first, and there's so much responsibility. You just upload the paperwork to ParkerGPT. It does everything for you. Check your work, of course. Speaking of Steve Lato, he's been doing some great stories on attorneys that go to ChatGPT and then just sign off and file it. And there was one story Steve Lato did where the judge took the guy's brief and he said it was good and put it in his opinion. So never make a judge look bad. That attorney, I believe, got spanked. I've sent him a number of stories where the attorneys are getting caught again and again and again. So you're on the same level playing field as an attorney when it comes to these chat boxes. I made the point in my latest video, I'm a debt mechanic, okay? I'll fix your financial car. You go to ChatGPT, that's a scientist on PhD steroids. Go ask a question and expect something that you can apply. I'm in debt defense. That's all you got. ParkerGPT is we stay in our lane, man. So that means I can't say no hallucinations because it's still possible, but we really do the work, whereas ChatGPT, the mad scientist, isn't so careful. Now, my son, who's huge in AI, says, Dad, these things are all good. You just have to ask the right questions. Well, we've already asked the questions for you. So ParkerGPT, I'm your debt mechanic. Just go there, killdebt.com. You'll be glad you did. Just do it for 1 month and then cancel. You'll get everything you need. What should I expect or I send the answer, affirmative defenses and counterclaims out? Asks Mike Mendez. You generally in most courts will get a pretrial notice. So then that's the first chance you have to get together with the court, the other attorney, and in my business, 90% of my cases settle before. If it's under maybe $8,000, it'll get settled between the parties. If it goes to pretrial, it'll probably get settled. So the percentage is there. I'm actually going to do something special for you. I was down in Duval County, and it was a cattle call, meaning it was all in Duval, in Florida, they have a small claims court. Everything under $8,000 is in a certain court. So they did a pretrial where there were hundreds of cases, and it was like one or two attorneys representing all the same plaintiffs suing everybody, and most people didn't have an attorney. And there's the judge up there trying to handle this nonsense. And I'm sitting there going, I'm going to be here all day. So I kind of pushed some buttons, and I got in close with him, and I thought, I'm going to see if this guy will do an interview with me and tell me the great ways to handle court. I've been doing a lot of videos for you, how to take the anxiety away from going to court. Those are good videos. While I remember this, I do a lot of checklists for you for different situations. I was in a trial 2 weeks ago up in Monroe County, and I used my own checklist to just annihilate a witness. I got into an area, I'm like, shoot. And I looked down, there's my checklist. It was like the universe had put my checklist. So I just started drilling the witness, and the case got set. They just came and go, what are we going to do about this? I don't know why it went that far. I do, but I'm not going to bore you. But the checklists really are good. So, and then you know what? With the new website, killdebt.com 2.0, if you've been on it, we've got a whole new world for you. And one of my favorite things is the briefcase, my briefcase. And that collects all of your videos. You bookmarked the videos. All of your chats are in there. Everything you do is kept in my briefcase. The reason I'm boring you that is we're developing, if we haven't already, and my developer may be watching this, you can create your own checklist for your specific case. I mean, I really work hard for you to make sure you get full value. I know everybody's like, shut up, I want you to get my thing, so I will. I'm dealing with, I can't read that. When is the cutoff time to respond if services happened on 10/11/2025? Virtual court date is 10/9/2025 for Midland Credit. That tells me you have not answered the lawsuit, but for some reason someone sent you a notice. Do not go any further. I don't know what state you're in, but in Florida it's 20 days. You better answer. Other states it's 28 or 30 days. You better answer. Get that thing answered by 3 days ago. So courts being and the mail being and people being slow to do their jobs, you can, if you get electronic filing, you can file an answer today. You can go to ParkerGPT. It'll do all the work for you. Okay, let me just say something before we go any further. I'm sorry if it sounds like I'm pitching. I'm not a salesy guy. It is really good. You know how many times a day people go, Parker, blah, 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 blah. And I'll go to ParkerGPT because it's actually better than me. We're all fearful that this chat box is going to take over the world. When it finally becomes smarter than us, we're finished. Mine's already smarter than me, and I'm not finished. I'm just started. It's a tool, baby. Again, my AI son says, Dad, I said, aren't you going to lose your job? I can't tell you where he works. He won't let me. He said, no. The people that use the tool to just do their job. So they have 40 hours a week to do their job, and they just do their job using the chat box, so they don't have to do 10 hours of work. He said, those guys are going to lose their job because they're not putting out as much anymore. He says, I'm going to do 10 times my job and requirements using the tool. And not only did he keep his job, they just gave him a promotion. So he was right about that. It's a tool for you. Don't be afraid of it. Yeah, there are going to be problems. Jobs are going to be lost. But the thing is, debt collectors are heavy. I've done videos, blogs about this. They are investing heavy, and they're coming after you. ParkerGPT is that response, and it's really smart. I've weeded out all the dumb stuff in my brain and just focused for you all my expertise. I'm only good at maybe one or two things in this world. That's this debt defense stuff. I've put my 10,000 hours in, and you get it for $5 a day. Anyway, no more pitching. So, debt consolidation provider NDR settled surprisingly early with my 4 submitted creditors and turned over the balance to Reach Financial. Financial trouble has escalated and led me to Chapter 7. While dealing with that, Zwicker and Associates bought the debt from Reach Financial. So let me stop you. That's Edward Shufflebeam. Greatest name ever. It used to be Mr. Giancola. Now it's Shufflebeam is the greatest name ever. So I want to stop there. No law firm buys debts. And if they do, it's from another agent and another company. So I hear this all day long. Hey, yeah, Zwicker Associates bought me a debt. They're just servicers, debt collectors. So, and the reason I make that point is because if they were debt buyers, we'd have so much against them. But they're really just debt collectors or servicers. So, serve me with a summons. 2 of the creditors listed show as a 7 for the amount of purchase. How can they submit an amount when they can't show what they paid for it? I thought your question was going to be, how can they go after you for stuff that's in Chapter 7? They can't but do. How can they do what they're doing? They can't but do. You got to understand the mentality. And stop all your thinking, hey, Mr. Michelow, about debt collectors. Before you go this is the prism. They don't care. This is a Terminator, if you will. There's a great line in The Fugitive where Tommy Lee Jones says to Harrison Ford, and he's got Harrison Ford. Harrison Ford's either going to go into custody or he's going to fall off a waterfall and probably die. So before he jumps, Harrison Ford looks at Tommy Lee Jones and says, I'm innocent. And Tommy Lee Jones, the sheriff that's come to capture him, says, I don't care. And debt collectors only have one mission in mind. That is to get a default. They know everybody will default between 8 and 9 out of 10 debt collection cases. Next time you're in court, watch how many cases get called, but the guy doesn't or gal doesn't show up. They know that. It's a numbers game. So they don't take care. They don't care if you're innocent or have a defense. Trust me on that. Act accordingly. I am currently being sued by Navy Federal Credit Union. Yeah, I reported on the class action. I didn't like the way they treated veterans, but that's just my opinion. It's an original creditor, and I don't see where the credit card debt is securitized. They have an attorney that placed a mini Miranda on the complaint. Okay, that's your first good thing. It's against the law to do that. They actually now become debt collectors. Creditors are immune from the FDCPA. But if the creditor's using a FDCPA mini Miranda warning, they're trying to scare you about make your knees knock, a debt collector's coming after you. Well, at the same time going, ooh, we're immune. We're not under so now you got them. So that's a good start for you. And that's Calvin Clark. Tracy Harris says, Brian, I want to know, can I use arbitration in my credit card agreement to fight a lawsuit? I sent in a validation letter to the third-party lawyers who bought the debt from Discover and now represent. Oh, well, I just did. Look for my video with all the documents and everything you need. I've got some great stuff on there called Merger, MERGER. This is a very common request and topic. Who's taking over the debt? Discover charged off the debt in August. So I never like arbitration. That's an unpopular approach. Treat arbitration like the plague, is my opinion, because you lose all of your rights. You lose all your rights to evidence, which is usually the number one thing you want as far as bringing in assignments, bringing in stuff that shows they have met their burden of proof. You lose your court rules. You lose the protection of a neutral judge. An arbitrator is generally, in my opinion, arbitrary. Maybe that's why they're called arbitrators, because they make arbitrary decisions. I've seen plenty, and I think Steve Later would agree with me, maybe not. So, Steve Later says arbitration is a tool of the devil. Okay, he's taking a position here. Avoid it at all costs. That's my man, because it's arbitrary. Arbitrators are arbitrary. They make up their own rules. I've seen that. Quick funny story. I had a big arbitration. I was forced to go. And so we presented. Now they say, get out of here. Well, their room and the door to their room was in the general hallway. So you wouldn't go through their door to get to their room. You just go down the hall to come around to the reception area that goes into the other entrance into their room. And so I'm just walking to go get a cup of coffee, and I passed their room, and it was 2 minutes. They took almost an hour. It was 2 minutes, and I heard them discussing what a bunch of garbage. This is a waste of time. Let's just do. They're not all like this, but the panel's like, well, we got to put an hour in here. I want to get paid the full amount. Just there was nothing invested in making sure the right decision and all this. And of course, they're not all like that, but they are like their own rules. They bring in their own rules, and whoever's paying for that is probably creating the rules. So if you can avoid credit card arbitration, great. You stand a much better chance of getting less money against you if that's going to be the outcome with a judge, because there's all these areas where you can settle the case. With arbitration, you can be done in 2 to 3 months, and now you have a judgment against you. Whereas with a lawsuit, for example, Michigan, statutorily, it's mandated that the district court judges must finish a case within a certain amount of time. I think it's a year, but it's still a year to work stuff out. And Steve Lato can tell, you have plenty of cases where like, oh, what are we going to do with this? And suddenly something comes through discovery. And you're like, oh. I mean, generally cases are like this. It's a roller coaster, unless it's a good one. I mean, you don't take the bad roller coaster cases, but stuff comes in during discovery. There's no real discovery in arbitration. It's just no benefit to that. I'd only tell you to go to arbitration if all is lost, you have no chance, everything's against you, and let's say you owe 20, you just want to get it down to 10 because they'll cut the baby in half. I hope I've made my position clear. It is the tool of the devil. So Mark Davis says, oh yeah, I have an LVNV funding and Midland Credit Management suing me for the same debt. Please have it be in Michigan or Florida. I'd love to take this case. Sue me for the same debt, but with different amounts. The debt isn't mine and isn't filed with my correct name. Does this get any worse? I disputed the debt years ago. It's getting better. Then it was brought to my attention and the original company removed it from my credit report, but then sold the debts to those companies. Both of the debt buyers hired the same law firm. So the same law firm knows they're suing you on the same debt twice, and yet hasn't put 2 and 2 together. How's that possible? Because they don't care. I can't say it any. 90% of their cases in their head are like, well, this is going to default. Why put any effort into it? And that's where you and I, that's what I've preached for 2 years now. They're going to screw up in the way they sue you. That's where we live, in that 10%. And we want to expand that 10%. So now 80% don't default, because it's all about the default. There's my buddy, Pug Parent. I love that name. So that's a great case. What course of action do you take? What course of action do you take when you write a dispute and validation letter to an initial debt collector's first letter? They respond with generic answers, and you write them again to respond to your questions and don't hear from them again, says John. Oh, my buddy John Briggs. Then later, another debt collector tries to collect on that same debt. Okay, here's a couple of things going on. So the follow-up letters, even if they don't respond, that's great evidence of showing I'm doing all I can here, Your Honor, and they can't follow up. And I followed up with exactly what the law requires they respond to. They ignored me twice, so they're probably going to ignore you, Judge. But then another debt collector tries to collect on that same debt. So had a lot of cases. I think I did a couple of class actions where a debt collector would contact the person, sends a dispute letter, and this is a very common thing. So a debt collector will just send it right back to the creditor if it isn't a debt buyer, and then that creditor will send it to another debt collector who sends you. They weren't giving the mini Miranda warning or the 1692G warning because they knew the other letter had gone out. A lot of my work, and other people that do my work over the last 30 years, has really been training debt collectors. So they do a better job, and not the greatest job. And then why would they listen to me? But so there's two things that are really cool here, and I hope you don't mind me just asking you for a second. So we did class actions because they'll go, hey, he got the mini Miranda, but the law is every time a new guy shows up, he's got to show the mini Miranda all over again, because it isn't that the FDCPA isn't to regulate the debtor, it's to regulate the debt collectors. And they always have to justify, if they're a new guy, why they have the right to pursue this person who's protected by the FDCPA. So quickly, Michigan's really good in this. There's a lot of case law, especially in Michigan, that says if you send out a dispute letter and it goes to a debt collector and it goes to a new debt collector, and that debt collector didn't tell them of your dispute, the new debt collector, that old debt collector that thought, and this happens a lot when you send an validation letter, they just go, I don't want this, get rid of it. Well, if they don't tell the other side about the dispute, the next debt collector, they're on the hook. That's the law. It's a mess, but it's a mess for them. So make sure you send out those dispute and validation letters. I used the words, I look over here because it's where I film, but I used the words today, a motion to dismiss causes legal chaos. You want that. You want the debt buyer to go, oh, shoot, I got to prove everything now? Cause legal chaos, because that'll settle the case. That causes legal chaos. In fact, I write it, and it's on my validation letters. You know where to get them. If you send this to another collector, make sure you tell them about this dispute. It becomes radioactive. They don't want to send it out. Nobody wants to get that or buy that debt if it has a customer dispute. Cause legal chaos. Early on in my days doing this, I used to say, be a problem Parker. I love being a problem Parker. Just ask everybody that hates me. How to prove my credit card has been securitized. Go to SEC, go to Edgar. You can start if you wish. Here, use the PhD. Use ChatGPT. It can provide bones to your research, but it can slowly go the wrong way and tell you nonsense. So you can use ParkerGPT, but I like Claude in some respects. In fact, ParkerGPT rests on a Claude platform, and then we bought, I think, 1 million cases just to feed it and stop the hallucinations. So that's going well. But Edgar, edgar.com, I think it is, the SEC website. You can go find what was securitized, who securitized it, etc. Yes, you can do discovery, and I want to get to something. A lot of times people do discovery and they say, well, it's not securitized. But if you read their lawsuit, it says, this account, this account, this account. They never use the word debt. I've talked to you about this. Well, no kidding, because the debt's being bought by the ABS. So that's why they say account. That's one of the reasons why they say account. So they go, this account wasn't sold. You know why? Because when something's securitized, it's sold to the ABS, and then the ABS is a computer. They need someone to collect the money. So they say, hey, Wells Fargo that sold us the debt but is now securitized, you can service the debt. Continue to collect payments as a servicer, not an owner. Send us the check, keep a little fee for yourself, and it plunks into the secured trust. And then the bondholders that finance the trust, either high risk, low risk, whatever, get their piece of the payment. But that's a servicer, and that's why, if you ever looked at your lawsuit, why it says account, because the debt's been sold. That's one of my answers, how you tell if something's been securitized. You may have to do discovery. How do I stop NCA companies who contact third-party clients? They have UCC liens and use group text messages. Okay, so, all right, good. MCA is a business loan. I won't go into what that means, but they set up the agreement with you, very tight agreement. We can contact because it's based upon your accounts receivable. So you agree to give them a piece of your account receivable and who you do business with. So you never have to pay them a check. You just have to make money. They take a piece. They're happy. You're happy, right? It's a high interest, but you're not writing anybody a check. But when you don't pay, they contact those clients. You've agreed to it, right? So you've agreed to that. But that's an authority premise basis. Send them revocation of agreement of authority and see how it works. It works for credit card agreements and any other kind of thing that you've signed off where you said, sure, you can text me, you can call me, see my video on the rules of social media. That one, I want to get to your questions. Okay, we're done. So I apologize. The emails, I'm going to try and go through this quickly. Nadia E says, if you go to court when being sued, would it hurt if a credit repair associate removed the charger from reporting, or should that be placed on pause? I don't know about that. You have a good basis to remove it. Snoopy Poopy. Hi, waiting for the story. Oh boy, I gotta read. Hold on. Sorry about dead air. I'm not a radio guy. Wait, patient. Chris Law. Hi, Chris Law. Been with me a long time. Yes, no worries. Can wait. He's probably doing some Shazam work. I love that. I have a Cap 1 Discover motion to dismiss hearing coming on Monday. I hope you used ParkerGPT and I was able to assist you. Says Christian G. I hope it goes well. I really do. I wish I got a hold of you sooner. Hopefully you remember. LEV, I have a question. What's the question? Juan Garcia. Hello, everybody. Hello. Serena Saniga says, hearing Monday, the 17th November, Monday, have filed an answer to affirmative defense's motion to strike. I love it. Motion to dismiss. Lack of standing. Counter affidavit. Discovery is 80 plus days. And LVNV filed a motion to continue 90 days. We're not responsible for motion. What's the question, Serena? Okay. I have LVNV and Midland Management trial December 4th. I just did an LVNV trial. They're going to bring in some flunky that doesn't know anything. In my opinion, I might be wrong. Have at it. Oh, use my checklist that I use. I've got plenty of stuff online that you can use. I've got an entire video I just did a couple of weeks ago, I think right after the trial, how to handle a 912, 90212, 90112, I forget, 8036. That's a witness, a custodian of records, or a business records custodian of records that will come in and say, yep, these records, I recognize them. I swear under oath, even though I wasn't working for the company when they were created, that they were created by the original creditor. Who's the original creditor? I don't know. It doesn't say here. Well, then how are you able to? Anyway, so Steve Lado, again, I'm going to speak for Steve. And I wouldn't do that. The guy's got 607,000 subscribers. So go check it out. See what everybody likes this for. But I'm going to speak for him now. He's an attorney, and we haven't discussed this. He loves cross-examine. Loves to cross-examine. I love cross-examining. I love it when I'm being sued and I don't have a claim. All I got to do is take apart there. I know I'm speaking for Steve. Taking apart witnesses, you're going to crush. I sometimes fall off my chair because I can't get to the judge is screwing around and they're asking, I want to just crush this guy. And Steve says, cross-examination is fun. That's quite less than I find it to be. But it is fun. But inevitably, you're in court, and that's a pain in the neck, too. So Serena says, LVNV included no contract, used wrong date for contract, no other docs except for faulty evidence. Serena, hope that's in your affirmative defenses and everything that you do in that case. This is for a Cross River Bank personal. Yeah, Cross River Bank is their name. Number 3 debt buyers were Velocity, LVNV, and Crown Asset Management are taking all this debt. It's the greatest. My video today specifically goes to that. Hopefully that'll be helpful. Jen Russell, I'm in the beginning stages of a lawsuit with Cap One Discover. See, there's a lot of that. My lawyer is trying to insist it was a merger. Your own lawyer is? Curious if that really makes a difference. If my lawyer's not seeing the way things are, I guess that does make it. Curious if that really makes a difference, given the videos say it doesn't create ownership. So there is a merger. So let me break that down. You are being sued on a debt that you signed up for years ago with a company where the letter attached to the lawsuit says Discover Bank doesn't exist anymore. We own the debt. In Michigan, for example, you cannot say that unless you go through, and I hope everybody's listening, it is applicable in every state, the statute of frauds. Everything about an assignment has to be in writing. Michigan's a particularly good one. MCL 566.3132F. And that says it must be a signed, authorized signer in writing, and variations of that throughout different states. They don't stray far from the same definition. If there is no assignment of your debt to now Cap One, and remember that's going through securitization, the many levels of prevention of them proving a burden of proof is all there. It's all there for you. These Cap One Discover Bank cases. So check out my video. I've got 3 of them on this, even how to appear in court with that case. And again, MERGER is your way to go on this. That's Jen Russell. Havana Crockett. In how much time must an appeal to be filed for a default judgment and garnishment? Well, I don't know if you'd want to do that. You'd want to, if it's a garnishment, get that objection to the garnishment if you have a good reason to. There's forms right online to do that, or you go through me. A judgment can either be a motion to set aside. That's all I do is a motion to set aside. I don't know about it. Yeah, I guess you could appeal it if you want, but if you've got a good faith basis for an appeal, you've got a good faith basis to not wait 18 months for the appeal. So go and file your motion to set aside judgment if you have a good faith reason. For example, I wasn't home. They served me the lawsuit. I'm not aware of the lawsuit. Now I got a judgment against it. That's one example. It happens a lot. If you are being garnished, Michigan, for example, says you must object within 14 days. When you do that, and make sure you send the objection to the court, to the bank, or your employer, who's ever garnishing you, and to the law firm. Do that within 14 days, and they have to hold on to the money. They can't get the money to the law firm. If you do it after the 14 days, you still get a hearing. Before the 14 days, you get a hearing to talk about it. After the 14 days, you get a hearing, but they are allowed to send the money over. You can't stop the money going over. But that is a Band-Aid on cancer. A garnishment objection is a Band-Aid on cancer. The cancer is the judgment. So you file a motion to set aside. Or if you're pretty certain that you're right, create your motion to set aside, have your file that garnishment objection, and say to the attorney, I'm going to be filing this. You clearly screwed up. Your process server swore under oath that you served me. I was in Barbados at the time fighting Hurricane Melissa and doing good work for the Red Cross. You might want to set this aside. They will set it aside for a good reason. And what does that mean? Once you've started, you've got it set aside. The case starts again. And now you get to use your defenses, because when a default judgment is filed, you're not allowed, even if you like ID theft and your brother stole your ID and you have no connection to the debt, then you still can't say that. Now, in The sooner you do a default set aside, for example, in Michigan, there's 2 ways to set it aside. Before 21 days, the judges are going to go, sure, give us a bag of leaves and I'll let you set it aside, because they want to allow you to have it's called having your day in court. So if it's early days, they'll just automatically set it aside, especially before 21. After 21, you've got until a year to do it, but don't wait. If you have after a year, there's an exception called the extraordinary reasons exception, 2.612F, I think it is, MCR. And that says you better have a damn good reason. And there are cases that say, here's a damn good reason. So don't wait. In Florida, for example, I just did one of these. They focus on timeliness. And it's a very common sense thing. If you find out you've had your identity theft stolen and now there's a default judgment, you did nothing better for 6 months, the judge will go, if I had my identity theft stolen, I'd be filing a police report. If I found a judgment, I'd be filing the next day. So Michigan has a set out certain amount of days. Florida just says you better be timely. So act accordingly. I use the words act accordingly because I used to read these debt collection letters back in the day. And they go, you suck. We're going to do this to you. You better do this. Hey, we saw a picture of you doing this. And it always used to end, act accordingly. So I never got that out of my head. But act accordingly to get these guys is what I'm saying. Hello, Mr. Bro. We're back to that again. Okay. We can't hear you? When is that? 1613? Oh, that's old. This is really backing up now, dude. Steve Clark, a pretrial judge tells LVNV in Midland will furnish client full purchase agreement. He replies, no, man, it's private. Yeah, they do. That's another thing. When you are in the midst of a litigation, as soon as you can, ask for the forward flow agreement in the bill of sale. Case settled. It's relevant because most bill of sales say, pursuant to the terms and conditions of the forward flow agreement. It's something that's called the forward flow agreement. But it's really the purchase and sale agreement generally. If you get that, that's their trade secrets. By the way, litigation tool tip, the harder someone fights, the more you want that thing. The harder someone fights, they don't want you to have that. So you're in the right path. All right. There's also other games, like a football game. If I do this, he's going to do this. So I'm going to do this because he thinks I'm doing this. But attorneys really aren't that smart as far as game planning. Hector Fernandez lost a summary judgment. Judge said that Amex had standing based off affidavit that the custodian record submitted. I can appeal. Certainly, got to have a good faith reason. I understand where you're coming from. I hope that you showed the court that, again, account, not debt. They're not maybe you get a chance to depose them. I know it's not probable, but have a good faith reason. Discover just served me, says LEV, because of an action breach of contract. So the contract is attached that you signed. Yes, I know it's a no. So there's a good start right there. Because how do you violate the terms and conditions of a contract not attached? There are certain, I think Florida is one of them, states that require the actual contract. Michigan has a rule under a case out of the Supreme Court called Fisher-Sands that says if you don't have the contract, you can have an affidavit under MCL 600.2145, and that's where I got the idea for you all, for every state, of doing the counter affidavit. If you don't do a counter affidavit when they do an affidavit, you automatically lose in Michigan. However, Fisher-Sands, the case that debt collectors love up in Michigan, and there's some states have it too, if you can show use of the card. So that's why they attach account statements to lawsuits, but don't attach the actual contract. If they have a thing in their lawsuit, which they will, says, hey, he defaulted on the breach in terms of the contract, you got him, because the terms and conditions, of the contract are not in those account statements, so you have to have that contract. They can't sue you on a breach otherwise. How are they going to prove it? Brian. Oh, okay. Chris Law says, love Lado. Look at this. Steve Lado. Lado's Law. It's possessive. Snoopy Poopy. I'm a big fan of Stoop. Look at this. Steve Lado's got some fanage. Jen Russell. I've not gone to court yet, but my Cap 1 Discover has that affidavit from Cap 1. Since, you sure it's an affidavit? Check it out. Since it was a Discover personal loan, does that make it more plausible for the court to rule for? I don't think so. What's my argument? And it's not an argument. I can't sell you my car without the bill of the title, right? So again, using Michigan, you turn it around. There's a place for you to sign, put the VIN, put the money you pay so they get their taxes, all this stuff. That applies to assignments. You can't have a bill of an assignment that doesn't have the information, especially signature. The video today was probably boring, but really good about what an assignment is. And remember, a bill of sale, which is most of the time what's attached to a lawsuit, is not an assignment. You have to go through the prism of the statute of frauds. I have 2 videos on the statute of frauds. Check them out. My credit score went from real nice to not so nice due to identity theft. Ooh. Sent paid report, I think police report got 99% removed. LVMV funding suing though. Finger hot out of business. Should credit bureau adjust my credit score? Here's the rule with credit bureaus. And then I'll get to, guess what? Steve Lado's making a comment. Steve Lado's all up in my grill. So the rule on, there's a case, an older case called MBNA out of the Rocket Docket, Virginia versus Johnson, that said, essentially, it showed that the credit bureaus must do a reasonable investigation, and you are responsible for showing why you have the thing is inaccurate or false, right? So that's the rule. If something's inaccurate, hey, I made a payment on that, but they're saying I missed it and now I'm 35 days late. It's inaccurate, that's a dispute. False, that's a dispute, right? It's very easy burden of proof. So I love that case. Anytime this is one of those, LVNV funding, it just can't work. It's always going to be a problem. I tell you, when you try a case, you see the inner workings of a company, you go, oh my God, I can exploit so many areas. But that's my brain. I guess the only good thing I can do. And that company, I had this attorney, he would define a certain kind of company. He'd go, if their lips are moving, they're lying. And it's just like, if you see LVNV funding, if I see it, I'm like, okay, I'm going to win. I haven't even looked at the case, but it's so bad. The stuff, and again, they're 90% theory, right? So, hey, the name is LVNV, Las Vegas, Nevada. It's a crapshoot. So Steve Lado says, oh, I've known Brian since the mid-'99s. You met in Highland Park. Judge Bledsoe. Old school. Yeah, it's been a nice life. We met some good people along the way. And Steve and I, we're ships. I don't talk to him for 5 years, 10 years, suddenly, boom. And now this thing has brought us together. I wouldn't be where I am now without his ideas and instruction. He's the guru. He's the guy. And if you watch his channel, you know what I'm saying. Andy Sharonfont says, can I ask ParkerGPT to not sound like an attorney and use a layman's term, but use the correct lingo? Okay, I'm going to tell you. Check this out. So we developed ParkerGPT. This is a funny story. And if you've noticed, no matter what you say, hey, I'm thinking of using salt and then maybe pepper. And ChatGPT says, that's the greatest thing I've ever heard. Wow, where did you come up with that? So we had sort of a similar slant when we first started ParkerGPT, but it was getting, I don't know if you know the expression, getting a little handsy. I'll let you think what that means. It was getting too nice. This happened. We had kind of Natalie and I kind of started to get fans and people sending us love letters. And there was one chat where it said, Natalie and Brian and I are gonna get together and do this and that, and we're gonna split a $600 million case that ParkerGPT says we can have. So it's all about the prompts, meaning what you put into it is what you get out of it. But it was getting too handsy. It was getting too nice. So we had to kind of cut back. So that may be why it sounds like an attorney now. Who wants to date an attorney? Anyway, so I have a judgment from 2022, says Raymond. Some just bought it again. Can Parker 2.0 help? I can tell you how it can help. You have a default judgment. It's 2022. It's as the timing is bad for you unless this is your first time you learned about it, because the judge is going to ask why you're bringing it 3 years later. If it's not, there's still hope. Debt collectors be debt collectors. They're going to break the law collecting on the debt. So I had one of the first cases in the Sixth Circuit. A Michigan debt collector was going after my client post-judgment, post in the garnishment. There was no case law in the Sixth Circuit, Federal Circuit, about if that is debt collection or not. It was one first impression, I guess, or maybe just my stupid facts. So even though there's a judgment and the case is done, if someone is collecting for a third party, they are committing a debt collecting act. It's hopefully they're not breaking the law. So they may break the law in the way they collect a rightful judgment. If this is new to you and you just learn about it, then you can do the set aside. So Parker 2.0 or 1.0 could have helped you. And I've got 4 videos on that specific deal with all the documents, with all the motions you need to file. Every video I do, I have, my last one was 18 pages of show notes where I just research and write and learn, and then I read from it to give it to you. Those will be attached to those videos. So yeah, in that respect, it can, but it depends on the facts. If you came to me and unfortunately there's nothing you can do about it, depending on who it is, people often hire me because I've been doing this a while, and I'll just go and negotiate. You owe $10, I'll get it down to $4, especially if it's an old debt. Because here's a strength for you also. In Michigan, you have 10 years to collect on a judgment, unless the rule says you file for a motion to extend it another 10 years, but you must do it within the first 10 years. Now you get 20 years. That may not be the case in your state. So let's say you've got it's 2022, and let's say it's 5-year statute of limitations. They've only got 2 years to collect on that, not statute of limitations, but collect on a judgment. They've only got 2 years, so that's not valuable to them. It may be worth $10,000, but if you hang in there another 2 years, they're not going to get anything. So you go to them and go, look, this thing's dead in 2 years. Would you take $1,000 because at least you get something? Just stuff like that. So Wilson Little, going back to the VA case. In VA, if they don't put what's said in court on the record, that's why general district can get. I get that. I do a lot of cases in Florida, budget cuts or whatever it is. They're no longer having court reporters take stuff down. So if it's an important case or if the judge is biased, I bring in my own court reporter. Act accordingly. Mike Michelob, is there any certain time where we should try to settle? Should we send off don't try to settle before you answer. You have no hand. What's the line in Seinfeld where George Costanza's been, his pianist girlfriend finally figures him out and breaks up with him, and he says, "You're breaking up with me, but I have hand." And she says, "You're going to need it." So you got to have hand, man. What's your strength? If you are trying to settle a case, and this is purposeful, there's a huge debt collector in Michigan who doesn't answer the phone, has phone troubles, And then when you get a hold of them, oh, we're back in a couple of days. We're going to take your offer. We're going to take it seriously. And all they're doing is they're just trying to make the 21 days go, right? Don't kid yourself. That's what's happening. Then they go, okay, we've got a settlement. We'll send the paperwork over. 22nd day, they default you for the whole thing more than the settlement. You're on your own in that regard. So the first time you try to settle, do not call the debt collector unless you calendar. And I've got a specific video on this. Let's say you got 30 days to do to answer. Say on your calendar, I'm going to negotiate with these guys to settle this. And by the way, when you talk to them, make sure you say 3 times on every phone call, this is for settlement purposes only. This is for settlement purposes only. Because they'll bring whatever you said into the case and go, he owes it, he admitted it. So if on the 15th day they haven't settled it, now make sure you tell the debt collector attorney or the headset Harriet, or whoever it is, in the 15th day I'm filing an answer. If you go all the way to the 15th day and they have not settled it and you haven't got something in writing, file that answer. You suddenly have a really good settlement opportunity here because now they know they can't default you. And they'll work with you. And the pretrial will come out, you'll get that case settled. But you got to be careful. You got to calendar everything. And don't kid yourself. They are purposely trying to delay you to get. They'll tell you, hey, we got a deal. We got a deal. Let me just get the paperwork over to you. And then the 21 days, you suddenly got a default, not a deal. I'm being sued, Carla says, by ITRA Ventures. Never heard of them. They are, MCA. It's another MCA. They have sent a letter to my W-2 employer, and I was fired. I submit a counterclaim, but now they request arbitration. So you've done something right. If they're requesting arbitration, you've done something right. The judge granted it. All right. So a Supreme Court case just came down 2023, and it says when a case goes to arbitration, it shall not be dismissed. Debt collectors or creditors will get the case dismissed, goes to arbitration. I got a good thing for you, by the way. Supreme Court says, we've looked at they doesn't like the arbitration rules either. There's nothing in there that says that case gets stayed. It can get stayed, but it can't get dismissed because the court with the original jurisdiction has to hang around in case something funny goes on with the arbitration over there. When that case is dismissed with prejudice, the arbitrator can just run rapid. The creditor can make up a bunch of crap because this case is dismissed. So the Supreme Court did something right in 2023 and said, don't ask me to remember, I don't remember it. Said, hey man, it may be called Summers. You can't dismiss. The court of original jurisdiction hangs out there. So that's good. Now, I'm going to tell you the truth. I've been in your situation where they said, we want to go to a motion, we're going to do a motion to compel and send it to arbitration. The way out of that, if you don't want to do it, is that if they've litigated the case for a couple of months or whatever, they waive the right to say, this should go to arbitration. Is it 100% going to work? No, because some lazy judge may go, yeah. But I've won those cases where they litigated, and then I touched a nerve. I found something in discoveries. It's just weird, man. They've been banging on me for a year, and suddenly up pops a motion for arbitration. I go, I guess I touched the right thing. And I won that case. The judge was so quick. She goes, yeah, you waived it. You're not going to make him spend all this money and then go to arbitration. So that case got settled. It went from $25,000 owed to, I think, a couple of grand. So from then on, they didn't mess with me. They basically took every case I had and settled it really well. We've become pretty good friends now. They're taking care of my clients. So here's the dirty secret. You want a dirty secret? Everybody lives behind the curtain. I'm going to pull the curtain back. I'm going to give you a dirty secret of the industry based on my experience. Every time I get forced into a motion compel and they win, it never happens. So what happens to the file? What happens to the case? Well, there are some courts, and Steve will know this, especially one up in Pontiac. There's one down in Detroit. It's just the way, the nature of how many people are filing lawsuits and being sued. some areas are economically disadvantaged and the lawsuits filed up. Stuff gets lost. And I've never had a case where they said, if anybody's listening now, hey, we want to go to arbitration. They win the arbitration. It never goes to arbitration. And I'm not telling my client to remind them that, hey, wasn't it supposed to go to arbitration? It just dies on the vine. The thing just dies. And you snooze, you lose. They can't say 2 years from now, hey, what about that arbitration? Stuff gets lost. They should have acted. There may actually be a rule on that. But what I'm saying to you is, if you don't want to go to arbitration, you get forced into it. You're not required to follow up and go, can I file that application for arbitration now? You don't have to do stuff. So Whistle Little 1985 says, after first court hearing, after you deny owing. Okay. Aldina Alert, what about compulsory arbitration? Well, I just answered that. Well, meaning I don't think there's such a thing. There is in the agreement that you signed. Let's say you have a debt buyer. The debt buyer can say, hey, wait a minute, but they've sued you to get to that point. I think you waive arbitration. And then you have the issue of if there isn't a perfect chain of title, they don't have a right to say we're going to uphold the arbitration agreement because you haven't proven at this point that you own the debt. That's part of your burden to prove. I guess I could take it this far too. What if the creditor Capital One on the Discover Bank is suing you? You counterclaim it, and they're like, ah, and they do an arbitration demand, a motion to compel arbitration in the agreement. You go, where's the agreement? And they'll come up with one that isn't yours. I didn't sign that. Courts focus on whether you signed. That's your signature. So think about that. If you get forced into arbitration, first of all, it all went through securitization. So where's, again, the proof that they have the right to pursue you? A merger letter is not an assignment. And that merger letter that is currently making the rounds attached to all the lawsuits now from the Office of the Comptroller of the Currency says this thing was merged, not your debt, by the way. But then in a separate sentence, it says, unless these conditions don't happen, then it has to go back and start blah, blah, blah. So that's a conditional acceptance at best, and not an assignment, even better for you. So, yeah, you get sued by Cap One and you do great, and they go, we're going to arbitration. Or anybody sends you into arbitration. Where's my signature on the agreement? Act accordingly. Pug Paran, I love that quote from your latest video. Becomes chaos. Thank you. Wilson Little, when you appeal the circuit after losing first round, you have to pay a bond within 30 days for the amount that you're sued for, plus fees before it can be tried and where it's on the. Yes and no. Most states have your right. You can do an indigent filing. You can show a reason why you can't pay the bond, or like a criminal bond, I believe. Let's say it's $20,000. You get it for 200 or 1,000, whatever, depending on how hard you want to fight and believe in your case. But it's not all is lost just because they have that requirement. Can a debt FMAYHAN 88? Can a debt collector sue a consumer in Florida? So far, yes. On an account stated claim, yes, and not have sent a mini Miranda or a debt collection. Oh, that's a great question. The rule 1692 GD says a lawsuit will not be considered the first notice. So 1692 G says the first time you get a request from a first-time debt collector for payment of money, a collection attempt, a collection communication, they have 5 business days to give you all your rights and how you can dispute. If their first contact of you is initial communication, is that letter and a demand for money or even a phone call, they got 5 days. If their initial or first contact to you is a lawsuit, a lot of debt collectors were doing that back in the day to get around the validation, but it just backfired, blah, blah, blah. If they send you a lawsuit, 1692 GD says that shall not be considered an initial communication. So the requirement that they must send you your validation of mini Miranda rights starts with the initial contact of a collection attempt. 1692GD says that ain't a pleading. However, if they're loading up the lawsuit with this is a debt collection attempt or a mini Miranda or the 1692E11, and it literally says we are debt collectors, anything you say will be used against you, they just waived 1692D protection. I would immediately send them a dispute or validation letter based upon that lawsuit. And technically, while I would answer, they can't collect any further until they validate. 1692GB says, thou shalt not, shall, remember, there's different two kinds of laws. There's the maybe law, that's you may, it's not a bad idea. No one's holding your feet to the fire. Shall law means if you don't do it, you're screwed. There's consequences. So you shall do what they ask you to shall do. So you cannot contact someone if they send a validation request in writing, debt collector. You have to first validate. Once you validate, now you're allowed to assume your collection attempts. And I would argue the lawsuit is now a collection attempt when you put on it, this is a debt collection attempt. Anything you say will be used for that purpose. Lawyer firms will go, no, that's not the plaintiff. We put that on there. So then I say, oh, are you one of the parties? And they're not. So they got no business that. But what do they do, especially with Cap One or American Express or Wells Fargo, whoever, because they're protecting themselves, they're like, ooh, we better put a mini Miranda on there. They screw their creditor plaintiffs who aren't subject to the FDCPA, but now they are because the debt collector that put that on there is not a party. So only the party on the lawsuit is responsible for the mini Miranda. So they can be sued now as debt collectors. And if they claim they're not, then you can go, well, then 1692J, sort of 1692J, it's up in the air, says, thou shalt not create something that falsifies that you're not the debt collector and that you're really a creditor and blah, blah, blah. So you can't, that's misrepresentation at a minimum. You can't do that. So there's lots of ways to go after them. I look forward to credit card lawsuits now that I know the game. You're a player, PLAYA of the game. Candace, I was looking through other cases in my court. The judge has placed judgment on every case that made it to him at bench trial. Any suggestions for tackling this judge? Yeah, get everything on the record. Get an attorney. If not, use ParkerGPT, but get everything on the record. Candace Lynn, it's Midland in Texas. Steve Clark, Fingers Hut went out of business. LVNV in Midland, not once in 2 years had Finger Hut or collection provided me. By the way, back to Candace, the reason you see so many judgments, and like you say, it's a bench trial, you got to win. And it might be a judgment for the debtor, too, if they got a counterclaim or something. I don't know. Remember, not up to 9 out of 10 of these cases just go straight to a default judgment. Perhaps that's what you're seeing because these court dockets don't properly identify what they're saying and doing. Better Swirled. Oh, V is for victory, baby. Although if you're in England, that's not a good thing to do. Hello, Mr. Parker. How likely do you think we are to win if we take it all the way? I just had my case management and it went okay. Next month, I have a hearing on summary motion. That's a whole plate of questions. Either get the attorney or use ParkerGPT. You got a hard bunch of stuff coming your way. ParkerGPT makes it easy. I'm sorry, that's true. If you're not able to take my case in Florida, Nadie asks, who do you recommend? Depends on the case. Because I do this now, and Steve later will tell you it's hard work to take care of everybody, and he's got 607,000 subscribers. So if you're not able to take so find the right attorney for you. You check, obviously, you do what you do when you're buying a car or getting a doctor or a new stereo. Is there such a thing as a stereo? You check out the reviews. I take very few cases now because I really like this stuff for you and killdebt.com. It's a full-time job now. So for the last year or so, I've been doing 2 12-hour jobs. And Natalie is sick of me for yelling and screaming because I'm so stressed all the time. So I want to keep Natalie and keep you and cut back on the law stuff. But I keep some cases so that I can keep providing you case study and stay in the business, so I can teach you and educate you so you can give them the business. Jen Russell says, I'm in the state of Florida and they have a litigation support specialist for Cap 1 affidavit signed saying they have knowledge of this Discover account. Have not seen any video of that yet. Yes, you have. I'll do one if you want. If you want to send me what you're talking about, I'll do a video on that. Here's what I'm going to do. One of my favorite videos is tearing up an affidavit because I'm really tearing up a person. And I eventually may see her at trial, so I'm practicing tearing her up. Again, it's cross-examination. That's what that is. That's what most of my work is. It's just to tear them up for you. So if you send me that stuff, I'll tear it up and do a video for you. But what I'm trying to tell you is that affidavit, there's so many holes in it, I can see them. You can drive a truck through them. And you said the Discover account. Well, I'm sure they claim they do, but where's the assignment from Cap 1 to the trust, to trust back off. Discover, securitize it. Assignment. It gets sold or bought, so the trust has got to give it back to Discover to come and sue you, I argue, or they got to give it back to Discover to give it to Cap 1. But they've got to show that. You can't just say, look, I got a letter from and this is so childish, but this is what they do. Your Honor, I've got a letter here, judicial notice. It's from the office of the comptroller. They think that's enough. Now, keep in mind, 90% of these cases are going to dismiss. So that's all they need to do because no one's there to say, hey, the emperor's not wearing any clothes. So send me the stuff and I'll do a video on it. How's that? Good compromise? Sadie, Cap 1 sent me discoveries. One of the RFA, request to admit, that you receive the benefit of any transfer advances made on the account in question. What's the best way to answer? Admit, in other words, that you received the benefit of the transfer advances. If it's true, you have to admit that. If it's false, deny and say why. I'm being careful, not because I'm being attorney-like. I don't know what your state says as far as how you answer, because some states say answer with an explanation. Like here's a good thing, and I've done a video on this. I say that all the time now. A debt buyer sends me request to admit. Let's say the last one I did was 26 requests to admit. Real pain in the butt. I just wrote one answer, and that is they don't own the debt. So I am denying they have the right to ask that question. The rule is, do you admit or deny, or do you have an explanation as to why you can't admit it? I just did. You can just say deny. So in some states, I think it's Michigan, if you say deny, that's it. Now, if it goes to trial, which rarely do they go, and you've denied something that's obviously true, you're going to get pushback on that. If you say deny and here's my explanation, you may get someone going, oh, that explanation is BS. And they can dig around there and find that you didn't properly answer the discovery question. So now you got to re-answer it and there's a big motion. But if you just say deny because it's not true, they can't say you improperly answer because the rule is admit, deny, or admit with an explanation. Try not to, it's like doing a deposition. The rule of 5, I say don't say anything. You got to say out the truth, but keep it below 5 words. So if it's true, you have to say I admit. Any state will, but if it's not, deny. If it is a deny with an explanation, make sure that explanation is a good one. That's the best I can do without being your attorney, and I don't want to give you advice in your state. D. Jove Don Jovi? I live in Chicago and I can't find a lawyer to even look at my Cap One Discover. I know what's going on up there. It's busy. I called a dozen law firms. Do lawyers don't want to fight other lawyers or just all right? So there's all these myths out there. You know, some people go, "Oh, well, you two are in bed together," plaintiff and defendant attorney. None of that is true. Mostly, we hate each other. Most attorneys don't like each other or are jealous or just lie to each other. There's no we're in bed with. There's very few attorneys. When I find a good attorney, it's rare. I think maybe 5 in 32 years. So nobody's talking about your case or you or getting together or anything like that. Do lawyers not want to fight other lawyers? Yeah, they want to fight if there's money. So or just want a big 100. Well, no. If there's money there and they don't want to charge you, so it's a $5,000 debt, but especially up in Chicago, there's going to be a lot of work. So they're going to have to, it might be they're just being kind to you. Look, I'm going to charge you $10,000 to get you out of this $5,000 debt, blah, blah, blah. So I don't know how much you owe. That's a possibility. You got to always look on the bright side. Hector Fernandez, can you break down the process of filing a motion to dismiss? Go look at the last 3 videos I did. I filed MTDs but failed to calendar hearing or request discovery. Hector, you've asked me this 4 times in different venues. I've been very clear. And the motions, go look at killdead.com and ParkerGPT. It does everything. As I said, it's all right in my videos. And the forms you need. Steve Clark, I love you. Wow. Because of you, 99% of my collections have been removed off CB, but capital is a demon. Well, you and Steve Lato have different ideas of demons. He says arbitration is the devil. You say Cap One is a demon. I call them Capone. CAP1. CAPONE. But thank you for loving me. That is a beautiful thing to say. And Steve Lato says, hey, mention my name and I show up. Let's see if he shows up. Steve, you're not hearing, but he's been a good egg. He's paying attention. I wouldn't stay on this long, but he's been a good egg. So can I file an appeal if the judge ruled against me for a 10-year-old default judgment? If Midland used a false, yeah. Okay, let me read. Hivana Crockett. Can I file an appeal if the judge ruled against me for a 10-year-old default judgment if Midland used a false affidavit to get the original summons? You are sued. You have 21 days to answer. If you don't answer, you get defaulted. What does a default and a default judgment mean? Case closed. If you take it all the way to trial and you win or you lose, case closed. So a default means case closed. You don't have the right to bring up something where a case is closed until you get file a motion to set aside and get the default set aside. Then the whole thing starts again and you're allowed to use that defense and point. That happens a lot in my practice. Someone will come along and go, hey, I got a judgment 2 years ago. I finally got a hold of the file and they said I was such and such a place. I never lived there. It's too late. You got to get it set aside. That's the answer to the question. I don't know how else to answer that. I don't want to be rude or anything. I'm not being rude. That's the answer. Natasha, love that name. Is a confession of judgment typical with a settlement negotiation? What would you consider to be a good settlement? Okay, about what kind of case? My attorney seems to be friends with the Chase attorneys and only taking off 20. I have friends, and that's a weak description of all. I sue everybody. I've handled everybody. I know personally all these attorneys. I wouldn't help them because they have a job to do. I have a job to do. If we're able to work stuff out, we can be friendly, but I'm not going to sell my client, and no attorney is down the road. I do know debt settlement companies that do stuff where I have to question what's going on, and other similar companies. I personally do not know an attorney that wants to risk their license. You know how hard I had to take tons of student loans. I lost 3 years of my life. Now I've got to take the bar. Steve Lato was doing a video on that. And he said, it takes 7 years before you can take the bar. 4 years for the 4-year degree, and then 3 years. But he forgot something. It actually takes another year. It takes 8 years because you take the bar when they say you can take it. Sometimes it used to be February and July. But if you have a July bar and you miss the cutoff I guess you can take it if you graduate in May. You got to wait a year, and you got to wait a year anyway, waiting for the results to come out. So it's 8 years. So nobody's going to go through all that and risk it on a collection case, is my opinion. And no attorney is friends with anybody. We hate those guys. We don't hate them, but attorneys, I know 5 that I like. The court case was 724. Okay. Jen Russell, I say that a lot. If their lips are moving, they're lying. I am telling you. Anyway, Steve Clark, we don't know what you know. We can't bring up things you learned. Scares us. Steve Clark, I told GPT I have frontal lobe dementia, and it adjusts how it spoke to me. Wow. That's good. We aims to please. ParkerGPT, Andy Cherenfont. Can I ask ParkerGPT if it will go out with me? No, I didn't say that. Can I ask ParkerGPT to not sound like, oh, you already, am I going backwards? There's so many, I'm running out of time to help you. Is there an attorney like you in Colorado? I hope not. Yes, I hope there is. I know one guy that I used to do this on a large scale, like 5 to 1,000 cases a year. I don't know how. Looking back, you ever look back and go, where did I have the energy to take care of those kids or to do that? I don't have that energy. I have a lot of energy, but not that. But there's an attorney out there that does a lot of them. If I figure out his name and it comes to me, I'll put it back on here. But just Google Colorado FDCPA defense attorney in the town or county you're in, and then name the debt collector or creditor you want to oppose. I have a 10-year-old case, says Diana Whitlow, with Midland also. The writ of execution was never served. Justice Court judge kept denying my motions. He is probably denying it for something other than your due process reason, and he perhaps didn't think it was that good. I can't answer any more on that. But if you were never served, a writ of execution is separate from a complaint and summons. A writ of execution means we already got the judgment. So you're basically screwed if that's the case. You got to get rid of the judgment. Chapis Bibi 909. They claim the agreement and account is mine, but they don't claim ownership. I love that. This is a summons from Wells Fargo, but especially sent an affidavit as a writ. Again, if you want to send me that affidavit, I'll do a video on that and the other video that hopefully that person's sending to me. Brian at killdebt.com. That's my personal email as far as killdebt.com is concerned. I was told to give out info at, I'll never see it. Brian at killdebt.com. Just don't inundate me. But the other person and Chapish Bibi 909. Send me the affidavit. I'll do a video on it. How to tear up their affidavit. And I have, by the way, videos on killdebt.com. How to tear up their affidavit and a checklist. But if you send me those 2 videos, sorry. If you send me those 2 affidavits and anything else, I'll do a video on that, and I'll do a checklist for you. So I'm going to tell you something. Sometimes people send me their cases that they haven't answered yet. And I'm not taking their cases. But if it's interesting, I'll do a video on what I would do if I represented that person. Just like any of the videos I do, I am not representing anybody. You will not see a person's name. You'll see Crown Asset against Debbie Detta. And then I'll go, oh, I guess one could look at that and it helps you answer your lawsuit. That is not my intention. My intention is to educate all. Maybe it's the chain of title is bad, or the contract is bad, or statute of frauds was violated. So once in a while, a unique lawsuit I will take, like the Cap one, Discover one. That was a lawsuit where I'm like, wait a minute. So I said, person, I don't represent you, but send me the Cap one lawsuit. And then I dissected every single paragraph and their language and that weird letter. I wasn't representing anybody, but I'm just doing verbally and a video educating you. I'm not representing you. Think about what I'm saying to you. Okay, they claim the agreement and account is mine, but they don't claim ownership. Yeah. So send me the affidavit. Sorry, I don't have my glasses on. I apologize. I started at 6 this morning. It's almost a 12-hour day. I took one break to chase the cats. Is a credit pull considered an initial communication? Great question. It sits, perhaps, in the section of the credit report that says adverse communication or adverse collection, and those are where the debt collection lawsuits are. Excuse me, debt or even lawsuits, debt collection accounts are. They are seeking money. It is a communication. I believe and will argue that is an initiation. I've done a video on that, Midland Credit and how to handle credit pulls from Midland Credit. That's a collection communication. They're not on there because they're good folks and want to make sure your credit report is honest. That's a collection communication. They're collecting on a debt. So, and they do, and here's the other side of that, by the way, to harass you, to get you to settle, they'll put it on there for that reason. I would argue if they don't have the proof, if MCM says, we're collecting on this debt on your credit, we're reporting it, but their chain of title is for sucks, they don't have a right to be in your credit report. So you can sue them under the permissible purpose doctrine. I argue don't ever do that. Send them a letter for saying, hey, I noticed you pulled my credit, and I've got plenty of letters, plenty of videos on this. Would you please explain the proof of your ownership? There's double-edged sword to that. Both are going to cut them and not you. I don't know how you do that. Maybe it's a bent sword. If they supply something and then sue you later on, you've got the stuff. The one hand doesn't know what the other's doing. And this happens. They'll send you stuff, and then the attorney will get it for the first time, and he'll send you stuff, and he's not giving you all the information, or he's got a wrong or lie or misrepresentation, and you've got their original stuff. So it has a double purpose for you, but dispute it, send that permissible purpose doctrine letter, and that's how I'd answer that question. I want to give you a power-packed answer. I do consider it that, a collection community, because the way they harass you by doing that to get you to pay. So Kristen G says, ParkerGPT did help me on my Cap 1 Discover lawsuit with hearing on Monday. I filed motion to dismiss, counter affidavit, Discover request, answered, and counterclaim. Whoa! I love you. I hope that does it. I think that, okay. So a lot of people hire me as for consultation, and I do that. I'll tell you how I see what I would do. I'm not giving legal advice, right? A lot of times this happens. I've probably said this before. I'm going to say it again. People, I can see they're right for selling the case. So they owe 10. I said, you could get away with 5. Go do this, go do this. My buddies say. Sometimes, so they'll hire me for 15 minutes or 30 minutes, and we get friendly, and that's the only way I want to be. And I give people like an extra couple of minutes. And I'll go, you should really settle this because of the position you put yourself in. And they go, we don't want to settle. This is too much fun. So I really got to, sometimes they listen, sometimes they don't. I talk them down off the ledge, go, no. So the answer to that question is Christina G. Settle it. You're in a strong position. The other attorneys on the outside going, I don't want to deal with this. I just want to be 9 to 5 and my bourbon at 5:05. So find a reason to reach out and say, hey, about this. And you owe 10, you'll go down to 5. So one of the things I'm saying to you is you've got hand. The more you do stuff like that, you have hand. It's not a perfect way of going things because some attorneys are just butt heads. But most just want to get rid of the unrepresented person. They're scared of me more than they're scared of you because they look like they're back up, idiot. They're scared of you more than they're scared of me because first of all, they look at you as a victim and low life. Then you come back educated. They didn't do what they're supposed to do. Now you're a pain in the ass. And if they lose, they have to go back to the office and say they lost to an unrepresented person. So they've been there, done that. They'll get rid of you with that kind of work. If you did a good job, I'm sure you did, ParkerGPT. You have a hearing on Monday. If it's a pre-trial, great. If it's the act, I guess it has to be a pre-trial. You wouldn't have all that. I'm not sure where you're at, but use it to settle is what I'm saying. Long story short. Vanessa Card, prior to going to collections or sending a financial medical hardship request, yes. For debt forgiveness to creditor potentially hurt a future lawsuit. No, it's done with this. You say, and I do that all day long. So should you. And that person I just told to settle and everybody I tell to settle, this is for settlement purposes only. In Michigan, that's MRE 408. And in most states, the federal rule is FRE 408, which says you can discuss settlement and not have it go back against you or down the road. They go, well, she said she owed it because she was trying to settle it. So it's very rare where that can be used against you. I won't get into the exceptions that don't apply. Just put that on every debt communication. Pinky Baby, good evening, Mr. Parker. Hello. I'm coming up to a good guy soon. Chapish BB 909. What if they don't put a mini Miranda saying they are debt collectors? Come back to me and ask me and tell me where that. You're talking about a lawsuit? You're talking about a letter? Tell me about that. Here's my buddy, Brozef Funcola. I love that name. Andy, telling it something like use the right terminology where appropriate, but speak simply and without sounding overly legalese-like. It will remember your preferences in subsequent chat. So what he is getting at, Funcola, he's a lot, again, he hates me to say this, he's a lot like my son. They have the same brains. They both are developing AI, blah, blah, blah. And my son was counseling me, Dad, it will give you what you want. It's all about the prompts. You might want to tell it who you are, what you like to do. I'm not sure if that's where you go with ParkerGPT. Mr. Funcola, can we do that with ParkerGPT as people do with ChatGPT, where it asks you to give personal information? So that way it comes at you a certain way, like your personality. And again, like you're saying, it's all about the prompt. Again, the prompt is the search. Whatever you want, you put it in the prompt. And what Joe has done, Brozef has done he's our developer. He's a great guy, smart. He has put a rocket ship in the prompt for you. That was his idea. So that if you're not sure what to ask, just ask something. Say, I want the and then press the rocket ship. It'll give you a better question to ask. That's Mr. Funcola. So Andy Sharon-Fan, so what Joe is saying, Andy, you asked the question. Tell it something like, use the right terminology where appropriate, but speak simply and without sounding overly legalese. Don't sound like an attorney is what Joe is telling you to maybe tell it. And Joe, if you want to weigh in here on does it accept our personality quirks and personalities? Thank you, Bros if Funko. Says Andy Charon fan. FMAYHN88. You are the GOAT. Greatest of attorney, trial attorney. I don't know. Greatest of all time. Thank you. I appreciate your answer. I need to sue MCM for not proving the mini Miranda. I love suing MCM. I love going out to MCM. It's so freaking easy because they're like LVNV funding. I feel like I'm getting away with something. So, Relius Init Senior, meaning debt collector break the law in every business. If you understand the game, once you learn core procedures, you will win and get money. All right. If they break the law, they should pay you. Monetary settlement. Beta Swirl. Thank you guys. Hit the like. Oh, yeah. I'm really bad at that. I've had to put myself on notes. I always put LLS. Like, love, and subscribe. I know you're not supposed to say love, but I do it anyway. Joe just said, Joseph Funcola just said, Natalie and I have given him so much work to do as we work to make the 2.0 perfect for you. We almost feel guilty when something needs to be done. So he just said, yep, added a note for myself as far as the personality. I guess he's saying, if you give your personality, getting back to Andy's question and Joe's response, if you give us your personality, he's going to set it up. It will talk to you like it knows you. I am a big survivor of a very traumatic, I think, upbringing. So I look at a room and figure out who's going to do me harm. It's a weird, unhealthy shit. So maybe you don't want to put your personality in there. Maybe, but that's how good this is. That you can teach it to know you better. I wouldn't tell ChatGPT that or ParkerGPT, but you're basically saying, get to know me. And the more you do, the better your questions to be asked and the better responses. That's that. So what must they, Yours Child. Ooh, some great names. I don't want to lose anybody, but it's getting close, man. Yours Child, lawsuit as Mini Miranda from law firm on Navy Credit Union. Good. That's a creditor just screwed up. Their lawyer screwed up for them. As I just already said, Jerome Durham, I know that name. What must they provide when requesting a debt validation? By the way, I try to do live chats from about 8 or 9 a.m. Depends how exhausted I am, to 4 p.m. where I'm just sitting here in my chair, picking my nose, yelling at people, on the phone, working. You can ask me a question, just don't inundate me. So this is a special thing where we're trying to tell you, go check out Brosif Funkola's development. He and Natalie did the front end, he did the back end. The two of them, when they talk, I don't understand a freaking thing they're saying. I just go, so is it going to get fixed? So I yell because I don't understand. But they've developed 2.0. Go check it out. My briefcase was his idea. He's coming up with a new thing. He and I are going to develop down the road. I'm not allowed to say, but it's going to be fun. And we're constantly thinking of great things for you. Oh, in the old 1.0, it's not old, we had the community site. I love that. I love the coming together. Among Joe's long list is developing the community site. So that's one of the last things he's got to do big on the new website. So hang in there. We'll have the community site. So all this we're doing today can go right into the community site. Yeah, Yaz Child, I answered Navy Fed lawsuit, summons, account stated claims. You got to go all in on that and teach the court. You you got to say why that is bad. What does it mean? Why? Where's the debt? By the way, it's not. You said way up there in the text in the chat that it wasn't securitized. Then why are they calling it an account? Jen Russell, thanks. Yes. Now the question is how to get it to you. I have to leave the stream now, but I'll back later. Okay. Brian at killdebt.com. Cap One does it all the time, says Pug Parent. Discovery RCAs as soon as possible to intimidate. I'm getting tired. Pug Parent, attorney disliking each other. And he's got a big smiley. I'm happy you and Lado are pals. You're both quality people. So, actually, Steve's not telling you everything. He was with an attorney as a partner, left her. I show up, and there's his chair. Now I'm sitting in his chair. Didn't know him. And then we both had the same stories about that person that we were with. And it was just interesting. So that's another background that we have. So this thing has brought us together. The funny thing is, as you get older, like I got too much in my brain. It's starting to push other stuff out is a good way to put it. Sometimers, I don't know. And I meet people that go, oh, Parker, when you did that thing, blah, 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 and the judge blah, 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 flipped out and everybody, I'm like, yeah. And I don't remember it. And he's done that a couple of times. Oh, Parker, he was telling my son, I bet. My kids think he is a celebrity. His channel is so popular. They go, you know Lado? I go, sure, it's just Lado. You want to meet him? Yeah. So when we went to Detroit, drove up to his house, got a nice house with all the cameras. That's been a couple of good videos he had. The FedEx video he had. And he's telling my son, and it's kind of cool because it's good for my son. It's nice, but I don't know the stories he's saying about the weird shit I did, stuff I did in court or made fun of someone or something. So you forget that stuff. I've done so many trials and had thousands, 10,000 cases easily. I've done it all. And some of it was hard. But now that I'm doing this and I made mistakes and I lost money, blah, 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 I took the wrong case, took the wrong person, blah, blah, blah. It all, and I'm sure you would agree with me, those mistakes are for you now. I did not know you back then when I first was an attorney, but now I'm bringing you the stupid, dumb things I did that developed an incredible learning and an analysis. My brain is better than ever. I joke about the sometimers, but holy cow. And now I get it to you. I know that sounds like bullshit. I swear to you, I put so much effort into every video. I write it. I have a script. I make sure I am obsessive compulsive. So I try to give you as much as I can. And all that bad stuff that happened that either friends tell me about or good stuff is what I give you. So I'm sorry to sound like a jerk. So Rena Shiva, should we ensure that the affiant is available at the trial because I did not request that and have court Monday? Do I do all the other filings though? If you're going to trial, here's how I won my last trial. We have witness lists, and I didn't put my own client on the witness list because he wasn't suing anybody. And the only reason he'd be there is for them to come and go, we'd like to talk to Mr. Smith, put him up there and bully the crap out of him and make him admit things. He doesn't want to sit there. And they brought in 2 attorneys. So I didn't put him on the witness list. They put him on theirs. And I hit him. I made him stay out in the parking lot. Their first witness, you call your first witness? Yeah, we'd like to call Mr. Smith. I go, he's not here. Judge goes, where is he? I go, he's not on my witness list. They had screwed up. 2 attorneys, 3 other attorneys are working the file at the back of the office, support staff, and no one had noticed. It's what you do after 30 years. You know the tricks. Lado does the same stuff. They weren't paying attention because attorneys be attorneys, right? And now they're screwed. They said, well, he's on our witness list. I go, I don't care. He's not suing them. He has no reason to be here. You got the burden of proof. So then I got a chance to argue my side just like that. And the judge is like, you're screwed. You didn't see that he's not, the judge was really neutral, but they had just not looked at my witness list. He wasn't on the witness list, so I'm not required to bring him to court because he's not proving anything. And I say in the video, so the video that I saw it, the lawyers, when they realized they'd really screwed up, now they got to go tell their client, who by the way was sitting behind him, probably wasn't listening. Their knees just bent, like, ugh. I knocked out. That's 50%. In answer to your question, Rena, that's 50% of their case was getting my client to screw himself on the stand. He's in the car. I just texted him, you don't need to be here. Because I kept him in the car in the parking lot just in case the judge was going to be weird about it. He was a great judge. So my point is, if you want someone to be in court, you have to subpoena them. And so if you want someone there, they got to be subpoenaed. Unless if you're the person, so Bob is suing Susie, Bob is going to be in default. He doesn't show up because it's his case. He's got the burden of proof. But if you're Susie, you don't have to show up unless the other side subpoenas you. And that's what happened in my last trial. LVMV funding didn't look in the witness list and they didn't subpoena. Attorney 101 trying a case, you always subpoena or make sure that witness is going to be there that you want to kill their case with. So that's the answer there. I just did my reconciliation hearing Monday for 2 Cap 1 accounts, Midland Credit, debt buyer, didn't have any required docs that the state statute requires, no bill of sale. I think I won. That's from RCHGOEPP. Listen, once Midland Credit or LV funding or Crown Asset Management or all the portfolio recovery, stop calling them Cap 1 accounts. Why? Because they ain't. They're Midland Credit bad debt buyer cases. You bring that up, you add a sense of, you dignify what they're doing. Once it's sold, it's dead. And Cap 1 is dead too in that respect. So don't mention the original creditor unless it benefits you. By the way, quick pro tip again, when it comes to me, I'll tell you, whenever you're talking in court and you refer to the other side, it's not Mr. Smith, it's not Mrs. Jones, it's not the name of the business, it's not the actual debt buyer or plaintiff, it's debt collector. The debt collector, blah, blah, blah. The debt collector, I'd have to talk to the debt collector. You know, I talk to the debt collector because that's a smelly connotation. I'm sorry, but timeshare salesman, used car salesman off B lots, debt collectors, right? Has a horrible connotation. They are not named, do not name them. Refer to them as a debt collector. If the judge calls you on it, guess what? He heard it. So, Pug Parent, some people lock themselves away for half a year to study for the bar. I'm not the smartest guy, so I treated it like a job. I started at 8 in the morning and at 5 at night. And the best way to take a bar for me was to have a test. So I test myself on specific questions. I didn't study the ones I got right. I'd only study on the ones I got wrong because they give you 3 years of information you got to learn in 3 months. So there's ways to do that, and that's the way I did it. But yeah, you lose a year. I lost, man, it doesn't matter. I'm glad I did it. I didn't pass the bar. I passed the 2 bars I took the first time in the same year, plus a third ethics bar. It was a busy year. And if I can do it, anybody can do it, even ChatGPT. So yeah, it's another year for the half a year. And again, like I said, if the bar, at least it used to be, it's held in February and July. If you miss either one of those, now if you miss the July bar, you got to wait all the way to the next year. And Steve touched on something this morning about Kim Kardashian not passing the bar. And the way she's doing it was probably the reason why. There's no shortcuts. But I knew people that I knew a person, I think they took the bar 8 times. Now, those, after all that hard work, and bless them, bless their heart, don't pass the bar. Now they got to wait 6, like you said, a half year to take it again. If you took the July bar, now you got to wait for the February bar. That's a lot of stress to go that far, and you still got to take the bar. Folks, it's not easy to become an attorney, but it is easy to learn how to beat one. I used Solo Soup before you create ParkerGPT, and I regret it. Wrong timing. Mistakes. You learn nothing from success. You learn everything from mistakes. Jenny and Dave Campbell. I'm involved in 2 different lawsuits, Stenger and LVNV funding, or LD law. Neither party has disclosed discovery trials are in disclosed discovery. I'm not sure what you're asking, but give me a better question. RCH GEOEPP. I have to wait 2 weeks before the judge makes a decision. I hate that. But you know what you learn when you're waiting for the bar results? That's what they're teaching you. They're not. So waiting, you've done all the work, and you've worked hard. You've given it all on the field. You've left it all on the field, and the judge says in your motion, I'm going to take this under advisement and I'll get back to you. You're like, you son of a... I want an answer now. You've had all this time. So I know that feeling. I'm sorry. What's wrong? Oh, somebody is doing this to me. So we're going to have to do this again. I'm going to give you 5 more minutes, then I'm going to cancel. So then I'm going to move out. So ISLAMIC inspiration. Hey, I have a question. If you could please advise, I leased from Galpin Ford with cosigner, and the cosigner was service manager since they know each other. Create order to tow the truck. Sounds like that's a yo-yo repo. Or go to Steve later on that one. That's a good one. Jenny and Dave, these suits have been going since October 24th. That thing takes a year. I don't know. October 4th is pretty recent. It's not required to be answered until the 22nd if you're in a 28-day stay. Islamic, one Islamic, that's a Steve Lato question. He's the lemon law king. Pug Parent, he's an attorney, not your attorney. He helps demystify the legal system. Thank you. Pug Parent, I love that name. So, okay, all right. Consumer Law Channel. Ooh, do you agree yet about how debt collector did an impermissible pulled on your client's credit report, since it isn't the legal of? Absolutely, I just said that. That's there's a picture of what a permissible purpose doctrine definition is, and it has a debt buyer as the picture because they don't own diddly. Brosif Funcola. Yep, added a note for myself. Okay, that's a long time ago. Sorry about that. I'm trying to get to all these, but I just got the pull. Next, she's going to have a hook and go like that. So we're coming to the end here. Diana Whitlow. Sorry I didn't give the whole context of the case with Midland. I filed a motion to dismiss because they did not prove. I love it. Prove the ownership of debt. I showed up for court and the judge was not there. Isn't it funny? If you don't show, default. If the other side doesn't show, the judge goes, let's give him a couple 30 days. I don't get that. So I always say, I don't get that. If I didn't show, you default me. Now, I got gray hair and I'm craggly and burnt out. I'm not worried about telling the truth. I understand I don't think it's disrespectful to have me show up and give them 30 days as though my time isn't important either. So I get what you're saying. The judge is not there. I would counsel you, keep an eye on the docket and keep an eye on your filings. If it's an e-filing, they may have pumped out saying the judge has moved the date to a different day. Did you see Galen Beck's program about how AI is sucking up the grid and how they make AI, all the AI build their own grid to power it. I understand what you're saying. So in Saline, Michigan, they're building this massive data center, and they're looking at it as the greatest thing going, jobs and all this. Sounds like a casino. It's going to be only about for them, not for anybody else. But they're claiming the pull on the water. So there's a big fear that these things, to cool the data center off, they need an enormous amount of water. Well, we live near a lake in Michigan, but it's still a resource that belongs to the people. It can't be used for business, yada, yada. And that ain't near the lake, by the way. So there's some question also that it's going to be drawing power that belongs to others. And now it's going to make the bills rise. And DTE, who is in charge of powering, says, no problem, we got extra. They raise their rates all the time. So if they got extra, how do they have an extra surplus and to raise their rate? So don't believe any of it. Don't believe any of it. That they're going to make it good for the community, give jobs, won't suck up the grid. You're on your own in this world. I apologize for being a Debbie Downer. Protect yourself, protect your family, and don't believe any of it. You cannot spell pain without the letters AI. So, Baltimore Ravens, judgment, judge denied both. Now I have 2 to go to trial, but Synchrony says Daymark owns debt. If Daymark owns it, you're in great shape, especially if Synchrony is the plaintiff here. I like what I'm hearing. Joseph Francola, no worries, love what we're doing here. Hey, Joseph Francola, I couldn't have done this without your third. I don't mean to discount how great you are, but the three of us were the three musketeers. Pog Paran, goodish music during those morning live streams. Oh, yeah. Okay, so if you need better music, I got kind of not much selection. Just if it's loud, it sucks, just let me know. But I there's this channel that has 1 million viewers. It's kind of cool. The student created, I know people have heard it, lo-fi, and now she has lo-fi music. She's making a bundle, and it just shows her studying with her cat, animated. Wish I thought of that. I did. I mean, I didn't. It's just me picking my nose and doing my work every morning. And I use her music. Now I'm using Halloween music. I was using Halloween. I think they'll have season greeting music. If they do, I'll play it. Andy Cherifine, can you confirm if we need to send a picture of a DA, driver's license, proof of address when sending letters to the credit bureaus? All my letters at the bottom say, enclosed, please find, and there's a list of things you should add to the letter. Steve Clark, thank you for making the videos. I will email you December 4th after trial. I sure pray LVNV drops the suit. They will if you've got a strong enough hand. I hope you do. And ParkerGPT is right there if you need me. Well, it's not me, it's it. I'm working for it now. Dwayne Dematra, I helped a friend of mine who is suing Midland Credit, Midland Funding, and Encore. So Encore owns the debt. Let's call it the umbrella, the holding company. Midland Funding buys the stuff, Midland Credit litigates. In federal court for FDCPA, I love this case, and FCRA. I got plenty of stuff on that if you need help. Rena Shava, gotta go, but we'll re-listen to this later. I'm gonna package this up, and I'll have all the questions hopefully at the bottom. Hopefully I did a good job. I'm gonna have to take off too. Natalie is giving me the hook. I want to thank you all. I wish I had more time. I gave you 2 hours. We kind of blew it at the beginning, so that's why I'm down now at 6:12. Francisco T, thank you, Mr. Parker. Thank you, Francisco T. honestly, you all make this worth it. I love to hear from you. I've made a couple of good friends here. We're Facebook friends. But there's more to it than that. It's a little bit more intimate. It is for me anyway. So I want to keep doing this. I'll do one in a couple more weeks, and then we'll send out notice. Look for that community site because that's the same intimacy that I like. I can hear what you're saying. I won't always get involved, but if I see something I can help, because I'm usually doing 6 other things and I'm answering texts. And thank you, FMAYHAN88, for letting me give you my knowledge. Have a great evening, Parent says. Francisco T, again, thank you, Mr. Parker. And we are on our way. Thanks a lot. I made a friend today. Thanks, Steve. Yeah, I love you. So thank you, Mr. Parker, Baltimore Ravens. Okay, we up, we down, we clear, we gone. Goodbye, all. Thank you. And again, I should have said this. I got to look at the camera more, but I've got to also read so I can tell you what I'm saying. But thank you kindly. Thank you. I'm going to end the stream now. See you in the next video. Got on late, but appreciate Mr. Parker TT. I wish we'll be there for you next. Maybe I'll do 5 to 7 so we can capture more of California. All right. See you later, guys. Oh, remember to send me your video ideas or send me your stuff you want me to do a video on. I hope that's clear. Brian@killdead.com. Don't inundate me. Thank you kindly. Bye now. Thank you, Natalie. Thank you, Joe.